Hello again and welcome back. Today's installment will be torts affecting business. And we're going to break this topic up into two installments, one for this upcoming week and then the week after. This week we'll focus on intentional torts and the week after unintentional torts. Let's talk about torts. A tort is a civil wrong other than for breach of contract. Tort law imposes upon the so-called tortfeasor the obligation to pay damages to the injured person. We've already studied contracts, so now we're going to study the other main common law component that represents civil law, and that would be the law of torts. Torts are divided into two categories: unintentional torts and intentional torts. When we talk about unintentional torts, we're really referring to negligence. And as I mentioned just a moment ago, that will be the subject matter for the next installment in a week or so. When we talk about intentional torts, obviously the key is intent. Intent is determined from an objective, reasonable person standard. It is not an internal subjective standard. Instead, a tortfeasor must have objectively, from the perspective of a third party, looking at the situation objectively and from afar, intended to commit injury or whose conduct was so reckless, so extreme, that tortious intent can be inferred by the circumstances. So, a tortfeasor must have objectively intended. Maybe in their minds there was no such intent actually foreseen or considered. However, if objectively the actions or their conduct reflected a level of intent, that's going to be the standard, because you'll never know what someone actually thinks in their mind, and the court is not going to take their testimony as true and accurate depending upon whatever their intentions are. It's what their intentions seem to be from a third-party perspective, and that's the objective reasonable person standard. Let's talk about the different types of torts in this particular study. And again, this whole chapter relates to torts as it may affect the legal environment of business. But these torts are common law torts that really are beyond just a business aspect. They relate to a lot of different contexts. But again, the analysis and the lens that we're using is how it affects or implicates the legal environment of business. So we're going to talk about in just a few minutes assault, battery, intentional infliction of mental distress, invasion of privacy, false imprisonment, trespass, conversion, defamation, fraud, and interference with business relations or interference with contract. So there's a host of intentional torts that we're going to be studying here this upcoming week, and it's all reflected in detail in your course chapters. Let's talk first about assault. Assault is the placing of another in immediate apprehension for his or her safety. It is an intentional and unexcused threat of immediate harmful or offensive contact, words or actions that create a reasonable belief that the threat of danger, the threat of oncoming physical interference and harm is immediate. So that's an assault. Assault is the placing of another in immediate apprehension for his or her safety. Overall, and we'll talk about this in just a moment, legal defenses are always going to be considered and may be available. Simply because there's an allegation that an assault occurred or a battery took place or a conversion resulted doesn't mean that there's not going to be applicable defenses. Always keep that in mind. When there is a claim that is posed, there's going to be, in most situations, most circumstances, a legal defense that can be considered. So the traditional legal defenses for intentional torts would be consent or justification. Let's talk about a battery. A battery is the offensive touching of another without permission or excuse. Often the battery will follow the assault. However, they are independent of torts. The battery often will take place immediately following the assault, but not always. Assault is a standalone tort, so-called, and a battery is also a standalone tort. Often they are used together to form claims, but they are truly independent torts. And whether the conduct is offensive is again to be determined by the reasonable person standard. The reasonable person standard is an objective test of how a reasonable person would have acted under the same circumstances and when viewed from an outside perspective. The tort of intentional infliction of mental distress. This is one of the newer torts in common law development. This tort was first recognized and labeled as the tort of outrage. It involves the tortfeasor's outrageous behavior, which causes mental distress upon the other. The other would be the victim of the infliction of distress. The infliction of distress. Outrageous conduct is really going to be the measure. To be actionable, the act must be extreme and outrageous to the point that it literally exceeds the bounds of decency accepted by society. Courts in many jurisdictions are going to be, how should I say this, wary or cautioned against finding behavior that's actionable unless the conduct is truly outrageous. It has to shock the conscience, in other words, of a general public response from the perspective of the court, so noting it. Generally, for infliction of mental distress claims to be actionable. When I use the term actionable, that means being legally recognized and allowed to proceed in a claim to ultimately a judge at a trial or a jury deciding on the case at trial. But generally, for there to be infliction of mental distress, the plaintiff has to prove not only distress, but also some physical ramifications or symptoms because of the distress. Now, courts in many jurisdictions are moving away from that general standard where there has to be some type of physical manifestation of the distress that is present. And in many jurisdictions, psychological testimony from experts, psychologists, psychiatrists could be allowed to show that there is distress that's been sustained, sometimes in the absence of any type of physical symptom or response. But generally, the rule still remains in most jurisdictions, for the majority of the courts, that physical symptoms because of the distress should be manifested to show the level of the extreme distress that was sustained. Let's talk about invasion of privacy. This is probably also one of the newest areas of common law tort development. The tort of invasion of privacy is a legal intrusion upon one's private interest. Invasion of privacy. For example, liability will be imposed upon a defendant, that's a tortfeasor, who appropriates the plaintiff's name or likeness for his or own use without consent. Another type of invasion of privacy is intrusion upon one's solitude. Examples of invasion of privacy in this context would be illegal searches or invasions of homes or possessions, illegal wiretappings, for example, as well. There are different types of invasion of privacy under common law. Let me just give you a few of these examples that are recognized in most jurisdictions. And this really goes beyond the content of your chapter, but I thought that you might have some interest in knowing some of the specific examples of invasion of privacy that courts recognize in most jurisdictions, certainly here in Illinois as well. There would be the intrusion into an individual's affairs or seclusion. And that would be the example I just gave. Searches, invasion of home, wiretapping, etc. There's also false light, invasion of privacy, that involves a publication that places a person in a so-called false light. For instance, writing a story that attributes to someone ideas or thoughts that places them in a very negative, very false light is a form of an invasion of privacy. You need to compare the difference between invasion of privacy, false light intrusion to defamation. They are different torts, and I'll talk about defamation in just a moment. There's also invasion of privacy that will entail public disclosure of private facts. That type of invasion of privacy occurs when a person publicly discloses private facts that an individual or an ordinary person would find to be objectionable or embarrassing. It might be true, but it really goes beyond the scope of what is reasonable and could be invasive. So the public disclosure of private facts is also recognized, and again, that's not covered in your textbook. I'm just providing that information for you here as just a little deeper context. And then there is the invasion of privacy, which is mentioned in the first paragraph here, that is where the appropriation of one's identity represents the intrusion. Using a person's name or picture or likeness or some other identifiable characteristic, especially for commercial purposes, without consent, will constitute, in most circumstances, an invasion of privacy. The key determination to make the invasion of privacy claim is first, is there an expectation of privacy? Is there an expectation of privacy? Courts determine what is reasonable privacy based on the facts of each case. Your textbook describes that. Disclosure to one or more people does not mean that a plaintiff has forfeited privacy rights, but where to draw the line is very specific to the circumstances of each case. Now, let me give you a for example. In your home or in your apartment, do you have a reasonable expectation that no one's going to intrude upon your own seclusion there or your privacy within those confines? Well, certainly. Now, do you have that same level of expectation of privacy when you're in a restaurant or when you're in a public park? Well, the answer is no. So expectation of privacy has to be measured based on location and the context. And when there is a reasonable expectation of privacy that is found, then if it's violated based on these different categories that I've just mentioned, there may be a cause of action for a plaintiff to pursue against a defendant. And the defendant, again, would be a tortfeasor when it comes to intentional torts. An invasion of privacy is an intentional tort. Let's talk about false imprisonment. False imprisonment. It involves really the intentional confinement or restraint of another person's activity without justification. It involves the unlawful detention of another without consent. It's a restraint against movement. The key component is to determine whether one's freedom to move about has been confined by the tortfeasor. Claims of false imprisonment often arise, and there's a section in your textbook about this, in the legal environment of business from circumstances, settings involving shoplifting. Shoplifting. Now, shoplifting is a form of theft. A shopkeeper does, however, have a legal privilege to reasonably confine or detain a customer suspected of shoplifting for a reasonable time. What constitutes a reasonable time, however, is often going to be measured by the circumstances and the context of what's involved. But false imprisonment is another example of an intentional tort. An intentional tort that, again, allows for a claim to be pursued where there has been interference of one's rights to move about. It's a restraint of their movement, and there's lots of examples. Business people, often in a commercial setting, a shopkeeper, they do have a so-called privilege to detain, but that privilege is only conditioned upon a reasonable time. Maybe from a practical perspective, the best alternative for a shopkeeper who suspects that there's a customer that is shoplifting is to contact the authorities and let the authorities deal with that situation rather than to take on the responsibility on their own. I'm going to share with you, I'll send it this week, I'll post it on your blackboard, a case that was decided many years ago here in Illinois, and it's a case, if I recall, involving the old Zayre. Zayre, you might not even remember it, it's long since, I think, gone out of business. The Zayre department store located in Elgin. Well, Elgin's pretty close to where we all live and work. It's within northern Illinois, and it's a case that was decided after it went to trial on appeal by the Illinois Appellate Court, Second Division. And I wanted you to see that case. It involves lots of allegations that not only relate to shopkeeper privilege, but allegations here of unlawful detention, the false imprisonment claim that we're studying, but it brings out some background information too. It relates to even race issues, which is in the opinion, but it will also contain information about damages for compensation and damages for punitive levels. And we'll talk about damages here at the conclusion of this discussion. But I'm going to pass around that case. It's still good law. It's current law many years ago, but it's still used, and it hasn't been overturned, and I think it gives us a good example that we can learn from with respect to this particular area of law. Let's talk about the tort of conversion. The tort of conversion. In fact, it involves one of the questions that I posted for your discussion board topics. So, conversion is the wrongful taking control of personal property, not real property. We'll get to real property here in just a second, and that involves a trespass. But conversion is the wrongful taking control of personal property belonging to another person without consent. Conversion also occurs when there has been a failure to return something that's been acquired and at a designated time, or delivery of something to the wrong party, or destruction or alteration of what belongs to another All are examples of conversion. And the focus is when the owner of that personal property has been deprived of their rights of ownership for an extended period of time or a permanent period of time. Conversion is, again, the unlawful and wrongful taking control of personal property. What's an example of personal property? Well, it's not real property. Real property would be land. Real property would be anything permanently affixed to land, such as buildings. Personal property would be a laptop computer, for example, a camera, for example, a cell phone, for example. Anything which is not permanently affixed to land, but does represent a matter that is subject to ownership rights. Well, when there's ownership rights that have been interfered with in a civil context, such as conversion, there will be a claim available for damages. Let's talk about trespass. Trespass is one I haven't mentioned yet. It's not on this slide. Trespass is when there has been interference with one's use of land. One's use of land. And trespass is when there's been unlawful interference, intrusion upon one's property without consent or excuse. So let's talk about defamation. Defamation is another intentional tort. Defamation is a broad-based term that really includes two subsets of that tort. Defamation is the publication of false or untrue statements about another that results in damage to one's reputation. What is key for there to be a defamation claim is publication. Now, publication means that the untrue statement must be communicated or made known to third parties. Let me give you an example. If Anne makes a very disparaging remark to Bob, and that remark or comment is accusatory and is saying or making the representation that Bob did something that is false, that it actually is false or untrue, but if the communication was directed to Bob from Anne, there's no outside publication. There's no communication that's been extended to a third person. Now let's change the facts for just a moment. If Anne claims that Bob did something, and that something is false and untrue and was communicated to Clara or Clyde to injure Bob's reputation, then that is going to fall in a category of defamation. There has to be a publication to a third source, not to the source involved in the communicated statement, but to an outside party. And from the perspective of that outside party, the other person's name, reputation has been harmed or damaged because of that communicated or published statement. The two categories are slander and libel. You probably have heard of these two categories. Establishing defamation involves proving the following elements. And these elements hold true for either of these two categories. Slander is the oral or verbal defamation that's communicated. Libel is the written defamation that is communicated, but both fall under the term defamation. To prove defamation, the following elements have to be established. One, that the defendant, who's the defendant? The tortfeasor, made a false statement of fact, not an opinion, but a statement of fact. That the statement was understood, number two, as being about the plaintiff and was designed or intended to harm that plaintiff's reputation. Their reputation for conducting their business, their reputation for honesty, and so forth. The third element would be where the statement was published, communicated to at least someone other than the public, other than the plaintiff. and that's a member of the public. That's, for example, a person out in the community named Clyde or Clara or a group of people. If the plaintiff is a public figure, then he or she must also prove actual malice, which I'm going to get to in just a moment. But those elements have to be established for there to be a claim that's actionable to constitute defamation. The defenses against claims of defamation include truth and privilege. So if what Ann communicated about Bob is true, then truth is a defense. Communications made in the context of litigation or testimonial proceedings are also generally privileged. In other words, if Ann is communicating information that is harmful to Bob's reputation, or Bob is communicating information harmful to Ann's reputation in the setting of litigation or where there's been testimonial evidence taken in proceedings, then those kinds of communication will be privileged. And that's a defense that can be raised. Let's talk about defamation. Now, we have covered in our studies already constitutional amendments, the First Amendment. Public figures are those who have consciously brought themselves into public attention, and sometimes they may not have intentionally brought themselves into public attention, but they've been thrust into the public limelight, which in turn could create this concept of that individual or person becoming a so-called public figure. Once a public figure status is determined, First Amendment protections will apply. For public figure defamation claims, malice must be established. Otherwise, there's going to be the First Amendment right of protection for the communication of so-called free speech. But malice, on the other hand, is the deliberate intent to injure or to communicate information that has been made with a reckless disregard for the truth. In other words, a deliberate intent to injure or harm that person's reputation, or it's been communicated with such a reckless disregard for the truth that malice is inferred. Let's talk about fraud. Again, another example of intentional torts. Intentional torts. Fraud is the intentional misrepresentation of a material fact that is justifiably relied upon by a person causing injury, and that constitutes civil fraud. Now, you may remember we talked about different standards of evidence in civil claims, and we talked about the standard of evidence called preponderance of the evidence. And that literally meant that it's more likely true than not true that the defendant did something that harmed the plaintiff. It's more likely true than not true. But when it comes to fraud claims, the plaintiff must not only show the existence of preponderance evidence, it's actually elevated to clear and convincing evidence. It's a higher standard against a defendant when it comes to intentional misrepresentation of facts. And the facts have to be material. You need to distinguish between a statement of fact versus opinion. Let's go through some of the elements involving fraud or misrepresentation that is a civil tort. One, there's a misrepresentation of material facts or conditions with the knowledge that they are indeed false or with this reckless disregard of the truth. So the defendant who's sued by the plaintiff is accused of making a misrepresentation of material facts. Now, what's a material fact? Something to the very essence or to the very core of the item or the subject matter involved. One of your discussion board questions involves the issue of intentional misrepresentation. So the second element would be where there has been that misrepresentation designed to induce another party to rely on that misrepresentation. And the third element would be that reliance upon the misrepresentation has indeed caused that party to suffer not only the deceit, they've been deceived by that representation that's false about the product or the item or the service, but then that reliance has resulted in actual damages or injury. Actual damages or injury. So there'd be a causal connection between the misrepresentation and the injury that's suffered. Now, I point out that you need to distinguish between a statement of fact versus just kind of mere puffery. And I think the law describes it as puffery. A puffery would be where there's been a gross exaggeration. And it's an exaggeration based on opinion rather than a statement of fact. So please note the difference. Fraud can also arise, besides the intentional misrepresentation, from the intentional concealment of material facts. But there must be established first a duty to disclose a material fact. Let me give you an example. Let's say that there's been a real estate offer and sale involved, offer of selling the property. In many jurisdictions, there has to be a representation made by the seller of residential property about certain known conditions. Well, if the condition of the residential property was such that it was subject to continued flooding or had been damaged by flooding before, then there has to be a disclosure in many jurisdictions about those conditions. And if that disclosure is intentionally withheld or concealed, when there's been a duty or an obligation imposed to disclose, then there may also be the tort of fraud based on concealment as opposed to misrepresentation. It's the concealment of facts, which in essence, is a misrepresentation of sorts as well. Let's talk about interference with relationships, with contracts. Trade disparagement, as noted in your textbook, is a business tort. It consists of the publication of untrue or false statements that disparage the business owner's product or its quality. The plaintiff must show actual damages resulting from the so-called injurious falsehood, however. And there's a section in your textbook that outlines that. One cannot intentionally interfere also with the contractual relations of another party designed to cause a breach of that contract. So imagine where a situation exists where Ann and Bob have a contract between each other. They've agreed to terms. And a third party has intentionally interfered with Ann and Bob's contract, such that the interference caused the breach of that contract. So let's say, for instance, that Ann and Bob enter into a contract and Clyde or Clara learn about the contract and want Bob to get out of or escape the contract. And there's an interference based on some representation that Clyde or Clara have made that would induce Bob to try to get out of or be excused from performance of that contract. Well, in some instances where that interference is intentional and it's designed to cause the breach of contract, then there's going to be a claim for interference with contractual relations. Now, what's required first is the existence of a contract and knowledge by the Clyde or Claras of the world that that contract exists. And their interference is designed to interrupt or damage the party's and encourage the parties not to continue with the performance of their obligations to each other. Let me give you some examples also of interference with contractual relations. You may have heard of the term covenant not to compete or covenants not to solicit. We'll talk about those types of employment aspects in the upcoming chapters in the next few weeks dealing with employment law. But a covenant not to compete would be where an employer, for example, employs an employee with the condition that they're not going to leave the company's employment and then directly compete for a period of time against that company's interest with a so-called competitor. So let's say, for example, company A hires Ann or Bob, and as a condition of employment, Ann or Bob have to sign a non-compete agreement promising that they are not going to compete after their employment ends with company A with any other organization that is competitive in nature with company A. For a non-compete to exist, there has to be certain conditions that are established by the court. Usually the conditions are the reasonability of time and the duration or the location of the restrictions, and there has to be an interest worth protecting. But that's where a third party may learn that they want to hire away Bob or Ann from company A, and they intentionally induce Ann or Bob, for their competitive reasons, to leave company A and join company B. If there was a covenant not to compete in place, there would be interference with that contractual relationship, that employment relationship between Ann and Bob, or Ann and company A, or Bob and company A, by that third party, that other company that is trying to induce Ann or Bob to leave and then compete against the organization by joining their company that would be a competitor. We'll talk more about that example when we learn about employment law in the next chapters upcoming. So I want to also discuss the overlap between intentional torts and crimes. Can intentional torts also overlap with what is considered to be criminal in nature? Now, we've not yet studied the chapter involving crimes. We will, but is there an overlap? Can the same sets of circumstances, the same conduct involved that can be civil, resulting in liability, also result in criminal culpability? And the answer is yes. Civil claims are between individuals. An individual that has been damaged by the actions of another may result, when there's a tort, for damages as a remedy. Now, the same conduct may be criminal in nature, and then the state is really the plaintiff, and the state would be pursuing the defendant based on violation of law, where the remedy is not monetary, but rather to be punitive, or to result in a jail sentence, or result in some type of an imposition of a fine, where, in other words, the state is the plaintiff and it has the public obligation to pursue the defendant for criminal actions, and the remedies are different. So can there be an overlap between intentional torts and crimes? And the answer is yes. Assault may also be a criminal assault. A battery may also be a criminal battery. A conversion may be a theft. I think you have the idea. Let's talk lastly about different types of damages. We've already touched on these terms for damages earlier in the course, but I want to, again, make sure we've got a very good understanding. And let's talk about the damages which are compensatory in nature. Now, the very root of the word is compensate. Compensate for what? Compensate for the injury or the harm the defendant tortfeasor in this instance caused the plaintiff. Compensation could be for pain and suffering, for humiliation, for embarrassment, or for loss of even some type of economic harm or damage. Now compare that level of damages as a remedy to the type of damages called punitive damages. Punitive damages are not designed to compensate. Instead, they are designed to punish the behavior, punish the conduct, and to deter, by example, that type of conduct or behavior from occurring again elsewhere. Not only by the same party, but by other parties that may have learned of this action and would be then deterred by example from committing the same level of conduct. So punitive damages are designed to punish. Compensatory damages are designed to compensate. Make sure you have a good understanding of those two types of damages. I think you do already, but I just want to make sure that we cover this again and in some detail. All right, that'll be the end of this segment. It's not obviously for settlement purposes, but for educational purposes. So, little misstatement there. So, anyway, it's for educational purposes only. I hope you've had a good week, and I hope you find this information helpful and further instructive for your needs here in learning about these chapters. Thanks always for your time and your attention and your willingness to consider. Have a good week.